Today, we're diving into a story about how a single checkbox, just a simple clerical error, can completely upend someone's life. It comes from the very heart of our justice system, where one little mistake didn't just cause a delay, it basically erased a person's fundamental rights.
It really makes you stop and think, right? This is the central, almost unbelievable question of this entire story. How does an ordinary citizen, someone with no criminal record at all, suddenly get treated by the courts as if they're a federal prisoner trying to appeal a conviction? You know, it sounds like a bureaucratic nightmare out of a movie, but this is exactly what happened.
This line, wow, it comes directly from an emergency court filing in the case. Just imagine having to write that, having to plead with a court to recognize the most basic fact about who you are. This one sentence just cuts right to the heart of the error and really sets the stage for a total breakdown in justice that should never have been possible.
Okay, so to understand just how catastrophic this mistake really was, we first have to talk about the law it completely undermined. And this was a landmark piece of legislation designed specifically to give victims a voice. So, for years, a lot of disputes, especially with employers or companies, were handled through something called forced arbitration. Basically, it's a private, out-of-court process. And yeah, it can be efficient, but a lot of people argue it often silences individuals and keeps really important issues like sexual harassment out of the public eye and away from a jury.
But then, in 2021, Congress passed the EFAP, and this was meant to change all of that. I mean, this law was a total game changer. It gives survivors of sexual assault and harassment the power to choose. They can't be forced into private arbitration anymore. They can finally have their day in court.
And here's the really crucial part. What makes this law so powerful? If a lawsuit includes a claim of sexual harassment, the EFAT applies to the entire case, all of it. This is huge because it stops the legal process from getting all tangled up by splitting a lawsuit. Sending one part to arbitration and another part to court. The whole thing gets to be heard together. So, the plaintiff in this story was trying to use this exact law to get her case heard in federal court. But a single clerical error sent her down a completely different legal path, into a world of justice where she didn't belong. And here it is. This is the mistake, confirmed by the court's own records. The plaintiff filed a civil motion to challenge an arbitration award, trying to use the EFAA. But a court clerk accidentally coded it as a motion to vacate, set aside, or correct sentence, also known as a 2255 motion. And that kind of filing, it's used exclusively by federal prisoners who are challenging their criminal sentences. And let me tell you, the difference between these two things is like night and day. On one side, you've got a civil motion. It's filed by a regular person, and it's all about a private arbitration. On the other side, you've got this Section 2255 petition. That's for a person in federal custody, and it's about their criminal sentence. They operate under completely different laws, for totally different reasons, and they're meant for entirely different people. And believe me, this isn't just some legal technicality. This coding stuff has huge, real-world consequences. This little tip from the court's own guide shows that how a case gets labeled literally determines your rights and what resources are available to you. For instance, the rules for getting court transcripts paid for by the government are different depending on what kind of prisoner petition it is. These codes dictate the actual mechanics of justice.
So once this case was shoved onto the wrong track, the fallout was immediate and it was severe. That one little error set off a chain reaction that just systematically denied the plaintiff her rights, one by one.
You can just see the dominoes falling here. First, the case gets misclassified. Because of that, it gets judged by a super harsh standard for frivolous prisoner appeals. And since the court thinks it's looking at a criminal case, the plaintiff's actual argument, the whole point of her filing, the EFAA, is completely ignored. It's not even considered. The final result? Her case is thrown out, and even her financial aid status to proceed with the case gets revoked.
Zero. That's right. That's how many times the plaintiff's actual legal arguments were ever looked at on their own merits. Not once. The court never evaluated her claims under the Federal Arbitration Act or the EFAA, the very laws her entire case was built on. The whole judicial review was based on a complete fiction. And the human cost of all of this? It's just been devastating. Court filings detail a complete denial of her right to be heard. But it goes way beyond the courtroom. She faced the loss of her home, her career, her financial stability, all while dealing with serious safety risks and the unbelievable emotional trauma of fighting a system that literally didn't even know who she was.
This quote from a legal filing really gets to a much deeper issue. The argument here is that this wasn't just some random accident. but a predictable outcome. The outcome of a system that is so complex and so unforgiving, especially for people who don't have a lawyer, that it makes them incredibly vulnerable to simple errors that can completely wreck their entire case.
And while this is the story of just one person, it raises some really serious questions about the safeguards in our justice system that affect all of us.
This here is from the court's own guide, and it points to a huge vulnerability in the system. It says it right there in black and white. Unlike in criminal cases, you have no constitutional right to a court-appointed lawyer in most civil cases. And that leaves so many people having to navigate this incredibly complicated world all by themselves as what's known as a pro se litigant.
So what does this all tell us? Well, this case is a pretty stark warning. It shows just how tough the system is for people trying to represent themselves. It proves that a landmark law like the EFA, a law written to protect the vulnerable, can be completely wiped out by a single data entry error. It really forces us to ask, if justice depends on the correct code being typed into a computer, how secure is it really?
And that leads us to the final, really unsettling question. This mistake was only discovered because the plaintiff fought so hard to get the official court records. So it just makes you wonder, how many other people have had their rights denied because of a similar mistake, a simple case of justice misclassified that was never ever caught?